So a warm welcome to our viewers and listeners. For those of you who don't know us, I'm Jonathan Hand.
And I'm Harriet Jerram.
And we've chosen a number of topics to speak about, all of which have an equine theme. We hope they'll be of interest. And the first of our topics that we're going to look at are practical issues that have come up in our cases recently. And Harriet, you were going to start with site visits.
With site visits. A site visit, I think, is an absolutely crucial part of really getting to the nuts and bolts of a case, understanding where an accident has happened, what the topography of the land is, where the relative, for example, vehicles might have been coming from. And I think it provides an unrivalled opportunity to really understand the case in a different way from photographs or descriptions in lay witness evidence or indeed expert evidence. I think the better it's better done in the early part of a case, and it can be just one side, just the other side. Often they are done on a joint basis, although my preference would be to go with my own team, equine expert, solicitors, and if for a defendant to have the defendant and say the staff at a stables, for example, there in situ.
Yeah, I'm just jumping in there. Something I always find it can be beneficial because for the defendant and witnesses, they're on home turf, if you like, and rather than what can sometimes be a bit intimidating, either in person or even on a video call for a conference. So yes, I think that's a really good point. Of course, it doesn't apply so much, or it's more difficult if you're for a claimant. But yes, and the other point which really follows on from that is evidence of the accident location, because although we may have an opportunity to go and have a look, as you say, with the site visit, unless you have a site visit during a trial, the judge, of course, is not going to know the lie of the land, and it is an issue that comes up from time to time, isn't it, as to how you get in evidence which is going to help the judge understand the accident location. And I think that the one important point that one has to bear in mind is how you're going to make it easy for your judge to understand the lie of the land and to get them on your side. And there's no one size fits all, but photographs, videos. Have you had a case with drone footage?
I haven't, but it's something I'm going to suggest in one of my cases. It's an accident that happened on a very big property with a horse bolting through the grounds of this property, and the factual evidence about where the horse went and what happened is actually very hard to fathom. And it occurred to me that if you put a drone up for 10 minutes and had a short video, that would explain things in a much more comprehensible way for the judge. Yeah,
I think it's a really good idea. Experts was the other thing that in practical terms often presents issues, doesn't it?
It does. I mean, obviously we always have our equestrian experts, but it can be useful, I think, to think more strategically about it in some cases. So, for example, in the Schultz case, which was a road traffic accident between a taxi and a horse, there were issues about whether under Section 22B of the Animals Act, the horse, well, there were two horses in fact, were displaying any particular characteristics. And for the defendant, we focused our accident reconstruction evidence on whether there was likely to have been any movement of the horse at the time of the impact. So accident reconstruction evidence was a central plank of the defendant's case, and it was useful. Yeah,
yes, and that was something that, because we were on opposing sides, of course, in that case, I think certainly contributed to the successful outcome for the defendant in that case. Yeah, I was looking at thinking about other expert disciplines that one might use, and looking back to the Lickey and Gibbons case a few years ago now, where the claimant called experts, Ryan Moore, the flat racing jockey, to deal with race riding, and also Jim McGrath in relation to the rules of racing. So that's a good example of a different type of expert being used to the equestrian experts that we're familiar with. one point that struck me about that case there was in relation to Ryan Moore, whose evidence the judge accepted ultimately, but there clearly were some issues in that case because remember he rather memorably said, according to the judgment, that he rides horses, he doesn't sit in front of a computer, and it turned out that his report had been prepared on the basis of notes that the solicitors had taken of conversations with him in person and over the phone, and then essentially they had put that into a report which he had approved. But that seemed to arouse the defendant's interest and concern, and they applied successfully disclosure of those notes, which were then used in the course of the trial, although ultimately, as I say, the judge accepted Ryan Moore's evidence and didn't have any concerns about the way in which his report had been prepared.
Yeah, difficult, I think, to reconcile that with the requirements of Part 35,
Well,
but
yeah, quite.
they got away with it.
They did. Just before we move on, and going back to the site visit point and experts, a bit of crossover here, what do you think about experts riding the horse?
Well, I think that can go one of two ways, really. I mean, obviously, if the horse is alleged to have particular behaviour and it displays that behaviour at the time that the expert's riding it, I suspect that can be determinative of the case. Many experts actually aren't prepared to get on a horse that's alleged to misbehave in some kind of way, which is not entirely surprising. But certainly for defendants, if one can demonstrate that the horse does not respond in the way that is alleged in particular circumstances, then that's probably useful evidence. Although I guess not many riders are as experienced and competent as some of the equine experts.
Yes, yeah. And there's always that, well, if you don't go and ride the horse, then are you going to be open to criticism, if you like, on the basis that you haven't gone and ridden the horse? Yeah, it is an issue that comes up from time to time. Yes. The other issue that comes up quite frequently in these cases under the Animals Act is how do you go about proving knowledge? It's always or can be a challenging issue, both for claimants and defendants. I was giving some thought from a claimant's point of view, because quite often one is having to consider how you are going to prove a keeper's knowledge, so a defendant's knowledge of the dangerous characteristics. And it rather depends on how you frame your case, it seems to me. If it's a case where you're relying on the second limb of paragraph B of section 2.2, so characteristics which are normal for the horse in particular circumstances, I think you can often put your case as a claimant on the basis that defendants are very experienced keeper, if that's the case, and therefore it's reasonable to infer from that they would have known about those sorts of characteristics. What can be more difficult is where you've got a horse that has a particular propensity to behave dangerously, and so you can't rely on that approach. And I think in that situation, certainly if a defendant won't admit to that particular knowledge, as a claimant you've got to start digging around to see if you can get any witnesses.
Yes, and also entries in the accident book and so on.
Yes, quite. Really, any evidence that you can put forward to show that the defendant must have known of this particular horse having a dangerous propensity in whatever way you allege.
And that can be quite difficult in circumstances, say for example a claim against a riding stables or a livery yard, where certainly in my experience people can close the ranks, and no one will actually say that they thought that horse was dangerous. So it can be uphill for the claimant.
Yeah, and I think that in some ways, should be one of the considerations for a claimant when you're thinking about framing your case. Obviously, it must be based on the evidence, but it is one of the difficulties of putting forward a case on the first limb of 2.2b, is that it does require that evidence of knowledge of a particular propensity, which can be difficult.
Yes.
Yeah.
I think for defendants, it's the issue of proving knowledge is really relevant to section 5.2 and the defence of voluntary assumption of risk.
Yeah.
And obviously there have been reported cases where defendants have known of claimants have known of a particular behavioural quirk but have accepted that and then gone on to suffer injury when that characteristic was exhibited. But as to the more general characteristics of horses that are displayed at particular times and particular circumstances, if you have a competent rider who suffers injury and is the claimant, often that equivalent knowledge that is alleged under Section 22C comes back to bite the claimant under Section 5.2 if they're at least as experienced as the defendant. And some of the ways of evidencing that for a defendant is through the rider registration form, witness evidence, and in some cases simply the experience or even BHS qualifications, for example, of the claimant, which can be very difficult for claimants to get around, I think.
Right. Good. And then I think the final point that you picked up as a sort of practical issue was social media
Yes.
as an evidential tool.
I mean, this can be a minefield, I think, for both parties. You know, if you're acting for a claimant and they say they're terribly injured and then they're on Facebook, you know, hanging off the Eiffel Tower, you know, you're in trouble with that. But also messages between the parties in the immediate aftermath of an accident, with someone at you know, at hospital and a defendant perhaps saying, "I'm really sorry about what happened today." Those things can be a minefield, and you know, obviously one is never involved in time to say please don't do those things, but it can be.
It can be fruitful ground for cross-examination. I think another example, I mean, that's after the accident, but also sometimes before the accident, there have been cases that we're both familiar with where there's an issue about whether a claimant has been employed by a defendant or not, and that, of course, can go amongst other things to whether the voluntary assumption of risk defence can be run. And that's and sometimes text messages or WhatsApp about the circumstances in which a claimant's been taken on, whether that points them to them being an employee or just taken on an ad hoc basis, can be quite important.
Yes.
What about case law? What's been going on recently?
Well, I was picking up on the Dennis and Vout Sales case. I mean, it's not a new case, it was decided in 2022. But I think in terms of the sort of practical issues to be thought about, that was a case that you may recall, a claimant sustained injury when she was showing a horse at an auction. And to my mind, it was a real demonstration of the risks of going to trial, where the key evidence about the accident circumstances were disputed, and the judge in that case held that the claimant simply tripped over rather than being injured by the horse when it was said to have shied or bucked. And I mean, it's a basic litigation point, isn't it? But it was a high risk in that case.
So that was 2022, wasn't it? Which was the same year that we had our Schultz case. And then, as far as I can tell, the only High Court equine case since then was last year, the Coetzee and Thomas case, which also has its interesting features. Looking back at it again, just as a refresher for those who aren't familiar with the case and don't or can't recall it now, because the judgment came out in October of last year. This was the case that involved a Dutch rider on a horse whilst he was on holiday in West Wales, riding out on the beach, and unfortunately his horse was spooked by a small terrier on the beach, and the horse reared up and bucked rather, and he was thrown off and suffered a severe spinal injury. And he brought a claim both against the owner of the dog and against the keeper of the horse that he was riding, the riding stables. The claim was brought on in negligence and under the Animals Act. The claims of negligence weren't successful really on their own facts, but it's the Animals Act that I think is quite interesting. The Animals Act claim against the stables only. Going back to the point that you were making earlier, Mr. Coetzee clearly was a very accomplished rider and had competed, amongst other things, in cross country, and over the years, and the judge made the point that the equivalence of knowledge between him and the defendant, and so whilst on the one hand he was able to satisfy paragraph C, equally it was held that he had knowledge of the risks involved in riding in those particular circumstances, that the horse might be spooked by a small dog that you could encounter on a beach, and so that was what put paid to his claim under the Animals Act.
Yes, and there were also arguments around Section 22A, weren't there?
There were, that's right, but he was able to establish that the requirements of Section 2.2 were made out, including Section 2.2A, in the particular circumstances.
2.2A was also in dispute in Dennis and Bout Sales, and the judge made some quite interesting comments on that, effectively saying that the question under the first limb of 2.2A is whether the damage likely to be caused by the horse unless restrained. And the judge was clear in that case that it wasn't appropriate to introduce other circumstances to try and refine the circumstances in which that injury was likely. It was said because that would introduce too much specificity to 2.2A and leaving 2.2B redundant. So that was quite an interesting approach there. That's also a good case if you need to try and work out in any of your cases whether the claimant was an employee, dealing with employment circumstances, reiterating that there is no single test for an employee. In that case, the question of control was important but not decisive. But control and management was with the defendant, and there was mutuality of obligation.
Yeah. It's interesting, all these issues, these sort of they're not sidelines, but they're not particularly personal injury issues, are they, that come up in these cases, employment being an example, that you need to understand those tests too.
Yes.
Yeah.
Just turning to recent events, we're recording this after the bolting of the household cavalry horses through central London on the 24th of April of 2024, and we're going to show you a clip of that now, just as a reminder. Jonathan, having looked at that rather harrowing clip,
it's shocking to see again, isn't it?
It is. To my mind, this is, although horrific for the animals involved, perhaps something that will raise public awareness about the nature of horses and their characters and how they can become spooked and then display the kind of behaviour that we've just seen in that clip. And I wonder whether that might be an area where, for example, in a case if you had a motorist who beeped at a horse and then it became very agitated and bolted and then damaged their car, it could be a point to put in cross-examination. Did you see that major news story about the horses, and were you aware that they could behave in that kind of way?
It goes back to some of those issues around knowledge that we were talking about earlier, and how you prove somebody's knowledge. And I think, yes, because it was such a shocking incident and got a lot of press coverage, I think people who might not otherwise be familiar with those sorts of characteristics will now be. I agree. The other thing that I think was striking about the case is that these were horses that, of course, are used to gun salutes, loud bands and so on, and yet I think there's a degree of uncertainty about quite what it was that spooked them, but something clearly did. So even well-trained horses can be spooked in some circumstances.
Yes, I guess that they would say that those horses would have to be bomb-proof to be in central London,
Quite.
parading and so on. But
But something says, I think it was 7 horses in total,
yeah,
and a number of whom threw their riders. So
yeah. The point I was just making about people driving rather recklessly around horses was also the subject of a release by the BHS of some video footage of different circumstances in which horses just got drivers got way too close to horses, and we'll show that at the end. But just a reminder that there were some changes to the Highway Code back in January of 2022, and the principal one being that people driving past ridden horses or horse-drawn vehicles where those are going at less than 10 miles an hour must allow at least 2 metres or 6.5 feet of space. So quite a significant increase on, I think before that it had been left rather vague, but
yeah, that's right.
This is very clear now.
Yes, and those were the first, I understand, the first changes to the Highway Code involving horses for about 30 years, and something that the VHS have been lobbying hard for over a number of years. But as the clip that we'll see shortly shows, it doesn't seem to have reached all members of the public.
No, absolutely.
Yeah.
And I think what the video footage really shows is that at least for some drivers, there's a real lack of knowledge around the sensitivity of horses. And clearly the BHS, well, in my view, were right to say this needs much closer enforcement and guidance.
Yeah. So that might be a good time to show the clip.
Whoa! That is exactly why you don't come flying down the lanes. Slow down!
So having seen the clip again, it does make for some pretty frightening viewing, and I think the riders involved, or the motorists involved rather, were lucky that they didn't cause a serious accident in some of those cases.
And you can understand, in fact, why riders are now often wearing cameras on their helmets to film this kind of incident. I guess if it happens regularly on particular country lanes and so forth.
Yeah. I mean, the other key change you're saying about in the Highway Code introducing specific distances and speeds and so on is the express hierarchy based on those most at risk of a collision. So you've got pedestrians, clearly the most vulnerable, but then the next group up are cyclists, riders, and those driving horse-drawn vehicles. And I think it's helpful to have that now, if you like, enshrined in the Highway Code. The difficulty is that those learning to drive now may be aware of the new provisions, but it'll take a while, I suspect, for others on the road perhaps to take it on board as well. Which is why the work the BHS is doing is so important.
Yes. Well, thank you very much for listening. We hope you found that useful.
Thank you.